With this Constitution, we created the federal government, a federation of states united for limited and enumerated purposes only, with all other powers reserved by the states or the people. In this little book, we listed the powers delegated to the federal government. It is only with respect to the enumerated powers that the federal government has lawful authority. As we discussed before, and I'll just repeat it because it's important, all our Constitution authorizes the federal government to do for the country at large falls into those four categories listed earlier: military defense, international commerce and relations, immigration and naturalization, domestically create a uniform commercial system, weights and measures, patents and copyrights, bankruptcy laws, money system based on gold and silver, mail delivery and some road building, and four, with some of the amendments, secure certain civil rights. That's it. All other powers are reserved by the states or the people, and the chart you'll be getting illustrates our glorious system on one page. It was our duty to enforce our Constitution and make our public servants obey it. But long ago, we stopped reading our Declaration and Constitution, and because we didn't know what they say, we were unable to do our duty to watch over and discipline our servants. We allowed our servants to bribe us into surrendering our liberties. That was the purpose of the unconstitutional government assistance programs of the early 1900s, Social Security in the 1930s, and Medicare in the 1960s, to demoralize us, strip us of personal responsibility, and make us dependents, so that we would dance to the tune of our servants instead of making them dance to ours. Their tune is tyranny. Our tune is the liberty enshrined in our Declaration and Constitution. The federal government has ignored our Constitution for 100 years. State governments have ignored it for 100 years. And we, the people who ordained and established it, don't have a clue what it says about anything. That is the problem: universal ignorance of these two documents. But organizations such as the Convention of States say the problem is the Constitution. They say the solution is amend the Constitution. Yes, when everybody ignores the Constitution and we, the people, have no idea what it says about anything, all we need to do is amend it and all will start obeying it. They say they want an Article 5 convention, and it's just to propose amendments. They say states will appoint the delegates, control the delegates, each state will get one vote at the convention, and Congress has no power over the convention. The states run the whole show. And they say they know this because law professor Rob Natelson says these were the customs followed in conventions, he says, took place all the time during our founding era. And they say Congress will follow these same customs when Congress calls a convention under Article 5. But folks, we have never had a convention under Article 5. So there is no precedent. Natelson's customs are irrelevant. Article 5 provides two methods of amending the Constitution. Congress proposes amendments or calls a convention to propose amendments if 34 states apply for it. The first method was used for our existing 27 amendments. Congress proposed them all. Under the second method, Congress calls the convention. A call is the official summons for a convention to take place. It states the date and location, how delegates will be appointed, etc. We all know what it means to call a meeting. If you call a meeting, you decide who, where, and when. Furthermore, Article 1, Section 8, last clause, the necessary and proper clause, delegates to Congress the power to make the laws to carry out the call. Now, Congress gets its legal research from the Congressional Research Service, the CRS. CRS just released a report to instruct Congress on the issues under an Article 5 convention. Here is a portion of the CRS report issued March the 7th, 2014. See me after, and I've got the information so you can find it online. The Congressional Research Service confirms that Article 5 delegates to Congress exclusive authority over both methods of amendment. The CRS report shows that in Congress's preliminary preparations for Article 5 conventions in the past, Congress has provided that delegates to an Article 5 convention would receive immunity from arrest, and Congress has planned to apportion delegates the same as in the Electoral College. So California would get 55 delegates and Alaska would get 3. So, if Congress permits the states to participate in the convention, Congress decides whether each state will get 1 vote or whether the state's electoral votes will determine how many votes they get. Congress may decide to appoint the delegates themselves. Nothing requires Congress to permit states to select delegates. Congress can appoint themselves as delegates. And Congress has the power to grant delegates immunity from prosecution. The Convention of States people insist they know exactly how a convention will operate, but page 25 of the Congressional Research Service report says, quote, "In the final analysis, the question, what sort of convention, is not likely to be resolved unless or until the 34-state threshold has been crossed and a convention assembles," end quote. The CRS says we'll have to get a convention before we know how it's going to operate.